You're watching the legal breakdown. So Glenn, this is the moment we've been waiting for. We are on the eve of Donald Trump's first criminal trial, which is set to begin tomorrow Monday, April 15th with jury selection. So I want to do a rundown of what to expect here, in this first criminal trial of a former US president. First of all and most importantly, is there anything that Trump can do to delay this trial from starting? Almost nothing. He may try to pull some, trick out of his dirty trick bag at the last minute. The one that we've talked about before, is perhaps trying to fire his lawyers and then, on Monday, say, "Judge, I need to hire new lawyers, and they need time to prepare for trial." The good news is, and that's a trick that is tried not infrequently, in criminal cases, when defendants desperately don't want to go to trial. But the good news is under those circumstances, the defense attorney would have to file a motion to withdraw, submit it to the judge, and the judge could grant it or deny it, and I can almost guarantee you, Judge Marchand would deny the motion to withdraw, would say whatever disagreement you have is between attorney and client, but we're going to trial, and you are remaining counsel of record on this case. Donald Trump could pretend to fall ill. I think we are just about guaranteed that this trial is going to start Monday morning. Now, what's the timeline of what to expect here? Starting with jury selection? Jury selection is projected to take a couple of weeks. I think that's about right in high-profile cases. Jury selection can take 1, 2, maybe 3 weeks. I think the best gauge is the Trump Organization criminal trial that was prosecuted by the same office. D.A.N.C.E. Chief Financial Officer Alan Weisselberg also pleaded guilty and ended up testifying in that case. I think it's going to take a little longer because it's Donald Trump, not just the Trump Organization on trial. So I think 2 weeks is a good gauge. Then they're going to go into opening statements, and then the prosecutors will begin presenting their evidence. I suspect the case in chief, that's what the government's case, when it is presenting, the evidence is called. The prosecution's case in chief will probably take maybe 2, 3, perhaps 4 weeks, and then once the prosecution rests, the case then shifts over to the defense, and the defense can put on a case. But importantly, everybody needs to remember that every defendant, including Donald Trump, is presumed innocent, and that presumption follows a defendant throughout the criminal trial, unless and until the prosecution has proved the defendant's guilt beyond a reasonable doubt. And it is because the presumption of innocence, and it is, because the burden never shifts to the defendant, that a defendant does not have to present a single witness, introduce a shred of evidence. In fact, believe it or not, Brian, a defense attorney, doesn't have to give an opening statement, or a closing argument. Of course, they almost always do, but it's impossible to predict how long the defense case might take to present, assuming they choose to present one, and I believe they will, but ordinarily, it doesn't last long, because defense attorneys up front will say, "Well, Judge, we have so much evidence to prove Donald Trump's innocence. We're going to call 50 witnesses," and then push comes to shove. By the time they get to the defense case, they might put on 2, 3, 4 witnesses. And then it'll go to closing arguments and then deliberations. Jury deliberations can take 1 day, 1 week, or 1 month. You can never gauge how long a jury will take to resolve the case. But I suspect we could see Donald Trump as a convicted felon, because of the quality and quantity of the evidence against him. He could be a convicted felon as early as June 1. Okay, now we've spoken about this in a previous episode of the Legal Breakdown, but how will jury selection work in a very blue city to ensure that they do see a fair and impartial jury? People may have this misconception that if somebody has strong feelings, or a really strong political affiliation or ideology, whether it's left or right, somehow they can't sit as a juror in a case involving a political figure, like a former president and leading candidate for the Republican nomination. Not true. People will come into the courtroom during the jury selection process, what's called Vader, and they will be asked a series of very probing questions by the judge, by the prosecutors, and by the defense attorneys, and everybody will be trying to gauge not whether they have strong political views, not whether they are really pro-Trump or really anti-Trump. They will be questioned about that, but after they're questioned about their feelings, and their views and their affiliations, and their ideologies, they will be, "Can you swear to us under oath?" Because jurors are put under oath during this process, subject to the penalties of perjury and contempt. Can you swear to us under oath that you can set aside your political beliefs, your views, your ideologies, your pro or anti-Trump feelings and judge this case, based solely on the facts, on the evidence that is introduced to you, during the course of the trial, and then we see what the answer is. Lots of jurors, Brian will say no, I can't be fair, obviously, they're excused, but the ones who genuinely, and that's the important word, genuinely, and everybody in that process, judge, prosecution, team and defense team, will be assessing the truthfulness, the candor, the genuineness of these answers. If they can genuinely say I can do that, I can be a fair and impartial juror, and decide this case only on the evidence I see and not my political views, or how I feel about Donald Trump, the person, those are the kind of people who will be qualified to sit as jurors, and then, once all of those jurors are qualified, you'll have a batch of maybe 30 jurors who end up being qualified, generally. Then what happens is each side gets 10 strikes, that are called peremptory strikes. These are strikes that you can exercise against 10 jurors for any reason at all. Like I got a really bad vibe from that one. Let me give you a quick example, because it's a really important example for I think people to hear and understand how jury selection process goes. When we're selecting a jury, we're generally standing 8 hours a day at the bench, at the judges' bench, and prosecution team on one side, defense team on the other, and the juror is called to the bench, and walks right between us, and begins answering questions first to the judge, then to the prosecutors, then to the defense, or then to the defense, and then to the prosecutors. The judge switches it up each time to be fair, and I have had jurors walk up to me during that process, and as I would see them coming up from the audience, I'd say, "Good morning, ma'am," and some of them would say, "Good morning." The defense attorney would say, "Good morning, ma'am," and the juror would go, "What did we just learn? Didn't we just learn that this person seems open and receptive to saying good morning to the prosecutor, and showed scorn and contempt to the defense attorney? We've just learned something about that jury, or not everything, but something, and so even if that's yours qualified, right?" Doesn't say anything that would disqualify them. They said, "I can set my political affiliations aside and be fair and impartial." The defense attorney would probably exercise one of his peremptory strikes against that juror, because just of that interaction, and that would be a valid reason to paramour strike that juror. There is only one reason that you cannot exercise your peremptory strikes: race. You can't look at somebody and say they're black, they're white, I'm striking them because of their race, or also gender and ethnicity, national origin. That's the Batson case from the Supreme Court said, you cannot strike somebody from jury service based on their race, and I think that's a really good and important rule. It was an important development in the law, in I believe 1986, when the Supreme Court decided the Batson case. Yeah, I'm glad they did it then, because God knows what this Supreme Court would have done with the same case. Glenn, let's skip ahead to conviction. Assuming that we get that far, there's the jury vote have to be unanimous to secure a conviction. It does a conviction or an acquittal. So if all 12 jurors agree that Donald Trump is guilty of the offenses, then they will vote guilty. That will be a conviction. If all 12 jurors agree that he did nothing wrong, he's not guilty, pure as a driven snow, little bit of an overstatement. If they conclude that the evidence doesn't prove his guilt, beyond a reasonable doubt, even if they have a very strong suspicion he committed the crimes, if all 12 say the proof has failed, we're voting not guilty. That's an acquittal, right? So, but if it's any other, num breakdown 11 to 1, 6 to 6, 8 to 4, one way or the other in favor of conviction or acquittal, it's a hung jury. And the good news is if the jury hangs well, the prosecution gets to retry the case. I retried more cases than I could ever count up over the years, because it's difficult to get 12 people to agree unanimously on anything, where to go to lunch, for example. But when you put the fate of a fellow human, being a peer of theirs, a jury of their peers in their hands, to decide whether the evidence proves guilt, beyond a reasonable doubt, and that person should be held accountable for the crimes they committed, getting 12 people to agree on